call whataboutism. They were saying, well, what about this and what about this? i.e. South Africa is not a very good friend of international law. South Africa is hypocritical. So why are they now saying they like international law? And my response to that is a very nearsighted and myopic view of South Africa's commitment to international law, because if you look at all the cases, and I'll mention just a few, what we see is an interesting dialogue between government and the courts, where government passes legislation domesticating obligations, and obviously our Constitution domesticates obligations. Sometimes government strays from them. The court says so, but then government pulls itself into the line and says, fine, we understand the law now, we're stopping. We've understood that. So as a whole, South Africa regularly and consistently complies with international law. To give you a few examples, we've talked about the al-Bashir case. Well, not only did al-Bashir have to sneak out the country, not any sort of red carpet for him, but he's never come back because the court accepted that, okay, there's no way that Mr. al-Bashir with the arrest warrant can ever come to South Africa, or we'll have to arrest him. Take the ICC withdrawal. The court is still part of the International Court of Justice because it accepted the court's ruling that it couldn't remove itself without Parliament's approval. Take Grace Mugabe. I know for a fact within months of the judgment, an arrest warrant was issued for Grace Mugabe, and she's never returned to South Africa because the government accepted the constraints of the international law and its constitution. Take the SADC Tribunal. The government was ordered to withdraw its signature from a new protocol that would have limited the tribunal's jurisdiction. President Ramaphosa complied with that and removed South Africa's signature. And it has stayed removed, and South Africa has never tried to re-enter that treaty. And of course, lastly, take Putin. As Max has already mentioned, Putin never came to South Africa. And if I can just take one step back, and Max has already alluded to this, compare this with the American approach. Because if you want to understand how radical our Constitution's embrace of international law, consider America. In the case that Max has mentioned, Defense for Children International Palestine versus the US government, versus Joe Biden and others. The US District Court, a federal court, after finding, in its own words, given evidence before it, not just the ICJ, that there was plausible genocide, finding that, it said, because of a doctrine in American law called the political question doctrine, which means that there's a no-go area when high policy is involved, because of that, it couldn't rule to stop America's support for the seizure of Gaza. Yet the court felt so conflicted that in its concluding paragraph, it said, this is one of those cases where the court wishes it didn't have to comply with the law. It wished that it wasn't like this because this situation calls for a resolution, and it called on the government to solve the problem, but its hands were tied. In our country, in South Africa, the court's hands are not tied, and government has always accepted that. All exercises of public power, all exercises from the highest public policy to the lowest, including international relations like the SADC Tribunal, are subject to judicial review, and the courts have and will hold government to account for domestic and international law. And that's why, in conclusion, I think I want to say this. In the final analysis, when we ask the question, has South Africa been hypocritical? Have they been a fair weather friend? I want to say certainly not. South Africa, when it instituted the proceedings against Israel in the ICJ, it wasn't an aberration born of expediency, as some have claimed. Rather, it was the culmination and outworking of a deep commitment to international law and human rights, which is woven into the very fabric of our Constitution, which has and will continue to guide, inform, and constrain all our actions, both domestically and abroad. Thank you very much.
Thank you so much. I'm going to invite or advocate Marumo Moerane SC to introduce our next speaker. Thank you.
Good day, ladies and gentlemen. The speaker I'm about to introduce actually needs no introduction. Anyone who was watching the proceedings before the International Court of Justice on the 11th of January this year knows the person I'm supposed to introduce. We all saw her masterfully introduce and set the tone for the arguments that were to follow on behalf of South Africa at the International Court of Justice. But being a loyal follower of instructions, I will carry out my instructions. Yeah. Adila Hassim SC was a constitutional law clerk to the late former Chief Justice Pius Langa and former Justice Cameron of the Constitutional Court. She was admitted to the Joburg Bar 21 years ago, 2003. In the 2000 years, she worked for the AIDS Law Project, and she took part in the treatment action campaign cases in which I was also involved. Adila co-edited what's this now? Health and Democracy, a guide to human rights and health, law and policy in post-apartheid South Africa in 2007, and the National Health Act, a guide in 2008. She helped to found the Public Interest Organization, Section 27, where she would serve as Director of Litigation. She's also a founding member of Corruption Watch. She's currently Senior Counsel at Thulamela Chambers in Sandton. Adila graduated with a Bachelor of Arts and Bachelor of Laws degrees from what was then the University of Natal, University of KwaZulu-Natal. She was awarded the Franklin Thomas Fellowship to pursue a Master of Laws at St. Louis University in Missouri, and graduated in 1999, and the Reverend Lewis Bradlow Foundation Fellowship to become a Doctor of Science of Law, JSD, at Notre Dame Law School in Indiana, which she completed in 2006. Both these degrees she completed summa cum laude. Now, to conclude, I think I need to teach Griffiths and Max Latin 101. You do not say sine cum laude. That's a contradiction in terms. It's either cum laude or sine laude. Adila, thank you.
How lucky am I to be introduced by a doyen of our legal profession, Moerane SC. Thank you for that. And like the speakers before me, I must thank the organizers of this conference and thank you for inviting me to participate in it. Thank you for all of the work in getting us here. Griffiths, I don't know how he managed to pull it all off, but here we are. And I'm going to be addressing you on this topic of genocide. The title of my presentation I cannot take credit for. It is Griffith's brainchild, but I'll do my best to sort of do justice to the title that he came up with. So what I will be doing is really addressing you on one of the gravest offenses against humanity, the crime of genocide. It's a term with heavy history and burdened with the weight of countless lives lost. But, despite its universal condemnation, the concept of genocide remains deeply contentious and evokes conflicting views and passionate disagreement. Yet grapple with it we must, if it is to have a meaningful application in international criminal law, not only in the form of punishment, but as a means of prevention. So what I'll do is I'll consider the definition of genocide under the Genocide Convention, the origin of the term, which informed the Genocide Convention, and what this means for the appropriate construction of the ambit of the crime. Ultimately, I argue that the definition in the Genocide Convention permits for a construction that is not unduly narrow, that is flexible, because it has to take account of the particular historical and factual context in which genocidal acts are alleged to take place, and that it must honor the overarching purpose of the convention, that is to prevent genocide, particularly by asserting an erga omnes obligation. So the topic is vast, and there have been many excellent scholarly contributions to this field. Mine is a modest offering that seeks to remind us that if the Genocide Convention is to achieve anything, it is to prevent the perpetration of genocide. And this is a very uneasy concept for lawyers, particularly criminal lawyers who trade in the world of punishment for crimes already committed. But let's give it a shot. I'll begin with the definition in the Genocide Convention. Article 2 of the Convention provides as follows. Genocide means any of the following acts, committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. Any of the following acts being A, killing members of the group, B, causing serious bodily or mental harm to members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or part, D, imposing measures intended to prevent births within the group, and E, forcibly transferring children of the group to another group. So as lawyers, the definition in the Genocide Convention is where we must locate our understanding, construction, and interpretation of the ambit of the crime that is so shocking that the fact of its very existence makes us question the depths of inhumanity. It was first described as the crime of crimes by its inventor, and it continues to be so described. The convention was signed in 1948. Philippe Sands describes it as the first human rights treaty of the modern era. It was signed and adopted on 9 December 1948, the day before the Universal Declaration of Human Rights was adopted. And it was signed 2 months after the UN partition of Palestine, dividing its territory to make way for the creation of an independent state of Israel. That was the context. of the coming into force of the Genocide Convention, voted in by the General Assembly at that time. A full 50 years elapsed before a conviction was secured for the heinous crime of genocide, and that was in the case of Jean-Paul Akayesu in 1998 for the Rwandan genocide. 50 years. This historical milestone underscores the profound complexity surrounding the term, which often sparks fervent debate upon its mere suggestion, irrespective of the accused party. The contentious nature of this discourse, it underscores the imperative to look deeply into the essence and implications of the term. Because if we fail to do that, then we can't begin to heed the command inherent in the Genocide Convention, never again. Because never again what? The allergy to the use of the word by those with power to prevent or to stop the Rwandan genocide, for example, is telling. In my reading of the transcripts of interviews with key players at the time of the Rwandan genocide, I was struck by the discomfort of calling what was happening genocide as it was unfolding. And I'd like to refer to a few of those. The first was in an interview with Anthony Lake, who is a national security advisor to President Clinton during the period of the Rwandan genocide. The interview took place in 15 December 2003, and the interviewer asks him, "Do you have any recollection of when it began to dawn on you that this is more than just a humanitarian crisis? This was something much more." And his answer was the following. He said, "My consciousness of it certainly grew. I'd say primarily from press reports. By May, although I knew bad things were happening there were news stories, for example, about bodies washing down rivers that were gaining our attention. But I guess it was not until June, maybe late May, early June." Just as an aside, remember that the genocide took place over a period of about 100 days between April and July 94. So he says it was not until June, he says, that it really got to be, and I saw it as, a serious problem. I obviously knew that it was a serious problem. That in later June, when I gave a talk at the White House Conference on Africa, I used the word genocide, even though I knew we weren't supposed to, because it looked like a genocide to me. Boutros Boutros-Ghali, the UN Secretary General at that time, says something similar. He was interviewed in January 2004, and in response to a question by the interviewer about why did you not say something about this being a genocide sooner, he responds as follows. "We have used the word genocide. Again, using the word genocide was to obtain the mobilization of the international society in favor of Rwanda. But when I was using the word genocide, I was not realizing that there was a real genocide. Why again? Because there is a definition. For us, genocide was the gas chamber. What happened in Germany? We were not able to realize that with the machete, you can create a genocide. Later, we understood this. But at the beginning, our definition of the genocide was what happened in Armenia in 1917 or 1919. It happened to the Jews in Europe, and we were not realizing. In our point of view, they have not the tools to do a genocide, which was the wrong perception. We were not realizing that with just a machete you can do a genocide." That was the UN Secretary General. In an interview, and this is the last reference I'll make, but I think that these are all really significant for us to understand how far we still have to go. It's an interview with Philippe Gaillard. He was the head of the International Committee of the Red Cross mission in Rwanda at the time that the genocide was taking place. And the interviewer asks him, he says, but the UN Security Council and even Dallaire, who was in charge of the UN peacekeeping mission in Rwanda at the time, who was outspoken about it being a genocide, but the interviewer says even he, to some extent, was just calling it a civil war. Philippe Guéard responds, in order not to use the word genocide, yes, that's why it was called a civil war. It's easier to use the word civil war legally. The Clinton administration was against the use of the word genocide, strongly against it. And the interviewer says, and you decided to be outspoken about it. And he says, I had to speak, to be outspoken in such a context, when you're seeing it every day in the streets, in your hospital, on the roads, in such circumstances, if you don't at least speak out clearly, you are participating in the genocide. If you just shut up when you see what you see, morally, ethically, you cannot shut up. It's a responsibility to speak out. It did not change anything. And it did not move the international community. I just can say that they cannot tell us or tell me that they didn't know. They were told every day what was happening there. So why is there such difficulty with calling the crime of genocide? Why is this so controversial? I think to truly grasp its significance, we have to look at its origin. And I'm going to do that now, the origin of the crime, but I must just first footnote a point, which is a topic all of its own, that genocides took place before the creation of the crime genocide. Most scholars of genocide note that such atrocities occurred much long before they were formally recognized as genocide. The Armenian genocide stands as a prime illustration. It's widely acknowledged as such, despite the fact that it preceded the formal codification of the term. Similarly, the genocide perpetrated by Germany in Namibia, though much less discussed, serves as another poignant example, and I'll return to the Namibian example. So the origin of the use of the word, the creation of the word genocide, comes from a Polish lawyer named Raphael Lemkin. Lemkin managed to escape the depravity of the Nazi regime, but he lost 49 members of his family in the Holocaust. It was at that time and in that horror that he began to develop his ideas regarding the term. So he introduced this term to the English lexicon and significantly international criminal law through its inclusion in the indictments that served before the Nuremberg Tribunal. And the term, as you all know now, it comes from Greek and Latin. Greek for geno, meaning tribe or people, and side, tside, from Latin to kill. Shabbos points out that Lemkin was likely activated by the Armenian genocide, which he studied as a student at Lvov University. So let's start with what Lemkin meant. He created and explained its concept in some detail in his 1944 book, Axis Rule in Occupied Europe, Laws of Occupation, Analysis of Government, Proposals for Redress. A more boring title you can't hope for. The term is associated with the Holocaust, and indeed it was the Holocaust that drove Lemkin to insist on the need for a new crime in which states would be held to account for the deliberate destruction of a group of people. The vast bulk of the book is an assiduous collection of the laws through which Nazi Germany carried out its genocidal program. And he justifies this exercise of collecting these laws, and he explains it quite drolly in his book as follows. The author feels that such evidence is especially necessary for the Anglo-Saxon reader who, with his innate respect for human rights and human personality, may be inclined to believe that the Axis regime could not possibly be as cruel and ruthless as it has been hitherto described. So he says, in light of that, it's incumbent upon me, he says, as the author, to collect this vast evidence of laws that show a systematic, orchestrated pattern that was clearly an intent to commit genocide. And then he explained the two phases of genocide, one being the destruction of the national pattern, destruction of the oppressed group, and the other is the imposition of a national pattern by the oppressor. He goes out to set out techniques of genocide. Now he draws these techniques, what he calls techniques. It's means of carrying out genocide through different modes. He calls them techniques. There are 8 of them that he sets out, and they occur in different fields. And the 8 that he sets out are political, and I'm not going to go into each of these terms. The book is something that has to be read. But the categories are political, in short, destroying self-government; social, by destroying social cohesion; cultural, by destroying cultural institutions and activities; economic, specifically shifting of wealth to the occupier; biological, the depopulation of a group; physical existence; religious, by interfering with activities of religious centers and places of worship; and moral, by attempts to create an atmosphere of moral debasement, as he describes it. He draws these elements and these techniques of the crime from his study of the laws of the Axis powers. And from this objective description of the synchronized collective of acts, genocidal intent can be inferred. The significance of this is apparent. Genocide takes place through multiple methods. Some viewed on their own may not appear to be criminal at all, even if they are oppressive and absurd. For example, one of the many laws in Lemkin's collection is a decree by the Axis powers in Poland prohibiting dancing. Yeah, a decree that prohibited dancing. The actual wording of the order, it's a very short little law, short little order. It's titled "The Order Concerning the Prohibition of Dancing" by the Government General, April 9, 1941. And then it prohibits dancing. So in developing the concept, Lemkin is trying to say something quite profound, which is it doesn't just manifest as killing. Genocide doesn't just manifest as killing. Indeed, mass killing is one of the 3 means. In the one category, the technique of physical destruction, killing is only one of 3 means in which physical destruction can be pursued, according to Lemkin. The other 2 being racial discrimination in the rationing of food and endangering health. As illustrative of this view, Lemkin quotes in a later article, and much easier to read, potted version of his book, if anyone's interested. He quotes the words of Marshal von Ransfeld, addressing the Reich War Academy in Berlin in 1943. And this is what von Ronsted said. He said, "One of the great mistakes of 1918 was to spare the civil life of the enemy countries, for it is necessary for us Germans to be always at least double the number of the people of the contiguous countries. We are therefore obliged to destroy at least 1/3 of their inhabitants. The only means is organized underfeeding, which in this case is better than machine guns." Close quote. So Lemkin draws out from all of this elements of the crime. And the first two elements that he sets out includes that the intent of the offenders is to destroy or degrade an entire national, religious, racial group by attacking the individual members of the group, and that this attack is a serious threat to either life, liberty, health, economic existence, or to all of them. So when we go back to the Genocide Convention then, and the definition in the Genocide Convention, and we know from the reading of the scholars and the travaux preparatoires that the definition is not exactly what Lemkin would have preferred. It's not as explicit and expansive as he would have preferred. It doesn't refer to cultural destruction, for example. It doesn't refer to forced displacement of an ethnic group from a territory. And Shabas tells us that there's no doubt that the drafters of the convention quite deliberately resisted attempts to encompass the phenomenon of ethnic cleansing within the punishable acts. They couldn't, given their own acts of forcible displacement through settlement at the time. So the consequence then is this potentially restrictive interpretation that jeopardizes the fundamental intent of the Genocide Convention, which is to prevent, to make real the vow of never again. An alternative viewpoint will suggest that genocide often advances insidiously. And if you view it from this perspective, it will align with Lemkin's rationale for compiling the myriad decrees and laws of the Axis powers that culminated in genocide, because individually, many of the measures may appear benign, but their collective implementation reveals the path to genocide. So when we are looking at the definition of genocide in the convention, I think it's important to go back to what it is that informed this definition. The court, the International Court of Justice, has famously now in the Bosnia-Serbia case in 2007 made its finding about ethnic cleansing, and that it is not a term that has legal significance on its own in the context of the Genocide Convention. And it said that even though it recognized that the General Assembly had associated ethnic cleansing with genocide, and specifically said ethnic cleansing is a form of genocide. The court said that's not tenable, it's not tenable as a legal construction of the Genocide Convention. But what the court also said, and I'll quote here from the judgment, it says, "This is not to say that acts described as ethnic cleansing may never constitute genocide, if they are such as to be characterized as, for example, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part," right? Article 2C. So if it fits within Article 2C, and the court goes on to say, and it's carried out with the necessary specific intent, that is to say, with the view to the destruction of the group, well then, it may be encompassed within the Genocide Convention. So the door is not closed. And I would say that the enumerated acts in Article 2 are certainly capacious enough to permit an expansive construction that recognizes forcible displacement as part of a pattern of events that can culminate in genocide. First, in accordance with Lemkin's own proposal, and specifically that genocide is not limited to killing, but also, as the court recognized, it can fall within Article 2C, provided it is accompanied by the requisite motive of deliberately inflicting on a group conditions calculated to bring about their destruction. And third, I would say that the coerced expulsion of a population from their ancestral lands surely threatens the destruction of an ethnic community. How does such a community persist without a rightful claim to its native soil, without the geographical anchor and ancestral heritage that form the bedrock of its ethnic identity? How can it be? It's not an immediate destruction, yes, but it's a slow erasure. And even a slow erasure ought to be accommodated within the definition of genocide. It calls to mind, for me, a personal story shared by Edward Said, and in his writings about the question of Palestine. Now, he was born in 1935 in Jerusalem, and he shares the story about when he was applying for a US passport because he was then exiled. His family was moved during the 1948 war. And so he has memories of Jerusalem, but he was never able to return. And he ends up via Britain in the US, and he applies for a US passport many years later. And in the process of applying for the passport, he records as place of birth Jerusalem, Palestine. But the authorities say to him, Jerusalem, Israel. And he said, no, Palestine. And they say, but Palestine doesn't exist anymore. And he said, well, Israel didn't exist when I was born. The point I'm trying to make here is about this third offering, about what it means to have an erasure of your identity as a result of forcible displacement. How do we understand this other than the extermination of a national identity? The expert historians Sanford, Cox, Trachtenberg have testified before the US District Court of California about a month ago. And they say in their testimony that history has taught us through the examples of forced displacement of the Herero by Germany in 1904, Armenians by the Ottomans in 1915, Polish Jews by Germany again in 1939, that this history has taught us how forced displacement has regularly escalated into systematic murder and genocide. So the motivation and intent, they say, behind the acts will be impossible to establish without interrogating the context. And in this sense, the context of a particular case cannot be underplayed. In the case of Palestine, Samudzi draws specific attention to the context of settler colonialism. And she writes, most recently, it was in January this year, the following. She says, the deliberate uncoupling of genocide from the study of settler colonialism in the case of Palestine not only produces an ahistorical record of the Israeli state, it also perpetuates an irrefutably exceptional Eurocentric ontology of victimhood, in which, and here she cites Dirk Moses, the moral cachet of indigenous survivors of colonialism is less than the Jewish victims of Nazism. End quote. That was what Samudzi said. Let me just be clear. Let me conclude then by coming closer to home. This allergy to the use of the term genocide, calling what happens by its proper name, persists. By coming closer to home, I'm talking about Namibia. Remember that genocide took place around 1904 to 1907. And in 1966, the German historian Horst Dreschler first argued that the German campaign against the Herero and Nama was tantamount to genocide. In all, about 75% of the entire Herero population and some 50% of the Nama population died during that campaign. That would make it the most effective genocides in the world. It took until 2021, I can't remember, I think it was May 2021, a joint declaration between Namibia and Germany. For Germany to come close 120 years later to accepting that what they did in Namibia was genocide. And I commend you to read the actual joint declaration. It's a masterclass in diplomatic language. But one sentence goes as follows. The German government acknowledges that the abominable atrocities during periods of the colonial war culminated in events that from today's perspective would be called genocide. Guarded language, not? I do not want to be mistaken for advocating the glib use of this term or for a shallow analysis of the elements of this crime. Not at all. It is, as Germany says, an abominable crime, even if they can't claim and confess to being the perpetrators. It's the crime of crimes. And it's a very, very serious allegation to make against any state. But that should not hold us back from scrutinizing conduct that may point towards a genocidal pattern and intent. As hard as this is to do amidst the chaos of conflict and the fog of war, we must do it. Because, and this is what really the essence of what I'm trying to convey in this talk is, we have to do that if we hope to achieve the goal of prevention. And that is what the Genocide Convention ought to be spurring us forward to do. Thank you.
Thank you so much, Adila. I just want to remind this audience that even though we have acknowledged all the organizers and the sponsors, each of these speakers also played the role of being a sponsor because, as you can imagine, all these lawyers are very expensive, and but none of them is being paid a cent for being here and making these presentations. May I invite Swintlagani Pochobe to invite the next speaker? Sorry, to introduce the next speaker.
Thank you so much. Thank you very much, program directors. My name is Ntlagani Kululeko Jobe, the director and founder of Jobe Attorneys, the leading black law firm in the province. Let me commence by greeting the leaders of the city, academics, scholars, colleagues. Mine is a simple task of introducing the next speaker. But firstly, I'd also like to greet our speakers, Advocate Andreas Cortides, Advocate Adila Hassim SC, Advocate Sarah Pudifin-Jones, Advocate Griffiths Madonsela SC, Advocate Max Duplessis SC, my personal favorite, Advocate Lerato Zialala, Advocate Temboyeka Ngwaitobi SC, and Advocate Tidiso Ramokhale. As junior as I am, I have had the privilege of engaging with the speakers that I've just mentioned. Oh, sorry, I'll be remiss not to also greet Advocate Marumo Moerane. Apologies for that. SC, of course. I've worked I've interacted directly or indirectly with the mentioned speakers, and I've also interacted casually and professionally with them. Most recently, I've just recently assisted Tsidi Soramogale, one of the ANC Women's League matters in the province, and I've also interacted with advocates Max du Plessis SC. This other point, when I was working for this big firm, I won't mention its name because I want to market it because I'm competing with it now. When we went to Advocate du Plessis' home in the north of Durban to drop off a brief, and what was memorable for me is that I was very nervous. In my head, I went there to just leave the brief with my colleague and then just run away. I mean, what else would I engage with the Max du Plessis SC? But ironically, when we got there, he offered to buy us coffee, and I quickly and instinctively denied because I couldn't wait to leave. I was nervous, but he insisted, and then we sat down, he bought us coffee, and that shows how welcoming Advocate Max du Plessis SC is. But my business is only limited to welcoming the next speaker. It could not have been more apt for me to introduce the following speaker, as he taught me both at undergrad level as well as master's level. The following speaker is very charismatic with unparalleled academic credentials. Having attended the University of KwaZulu-Natal, he was loved by many and hated by none. Most females at law school thought he was physically charming. But contrary to us thinkers, we thought he was intellectually charming. He teaches international law at undergraduate level, constitutional theory, law and litigation at master's level at the University of KwaZulu-Natal, of which I am part of as well. He's a senior fellow Melbourne Law School and has numerous degrees from the University of KwaZulu-Natal, London School of Economics and Political Sciences, and Melbourne Law School. He has held fellowship at the Harvard University as well as Oxford University. He is a member of the editorial board of the South African Journal of Human Rights. He has participated as an amicus curiae in cases before the United States Supreme Court and the Israel Supreme Court, and is assisted in the Causes 4 case. He was part of the first crimes against humanity prosecution in South Africa and first prosecution of the crime of apartheid before domestic and international court. Ladies and gentlemen, please welcome Dr. Christopher Givers.
So I'm an academic, and as an academic, I'm going to take the prerogative of an academic and break all the rules. So I refused the title that was sent to me by Griffiths, and I chose my own. I'm going to tell a story and make 4 points, and I'm going to speak about the RCJ case. Right? So let me begin with a disclaimer of sorts about my title, which is Tell No Lies, Claim No Easy Victories, which many of you will recognize from the writings of Amilcar Cabral. It is by no means intended to suggest that the recent remarkable victory of South Africa at the International Court of Justice was easy, let alone false. South Africa won every legal argument it possibly could have, and Israel lost every argument it made. What I am interested in reflecting on is what that remarkable victory means for the court and international law, both historically and going forward to the merit stage. So in doing so, I want to invoke Cabral's aphorism, the full version of which is as follows: tell no lies, expose lies whenever they are told, mask no difficulties, mistakes, or failures, claim no easy victories. And I want to invoke it as a lesson and a warning. And I want to use each of these directives to say 4 things about the significance of the case for South Africa, for international law, and for a just international order. So in order to do so, let me begin by returning to South Africa's first appearance in contentious proceedings at the ICJ in the 1960s, in a case brought against South Africa by Liberia and Ethiopia, acting on behalf of newly independent African states, challenging the implementation of apartheid in then Southwest Africa, and by extension, the implementation of apartheid in South Africa as well. So the details of what became known as the 1966 Southwest Africa case decision, are well known to international lawyers, who would sooner rather forget them. In short, after a preliminary decision in 1962, confirming that Liberia and Ethiopia is standing to bring the case, and a full hearing on the merits, in 1966, a reconfigured bench by the casting vote of the Australian Judge President took the extraordinary step of revisiting and reversing its decision in 1962 on standing, finding that Liberia and Ethiopia, in fact, had no legal interest in the matter. So it was later revealed that the reconfiguration of that bench in 1966 was engineered by fraud and collusion on the part of the old guard of white judges, led by those of Australia and the United Kingdom. The impact of the 1966 decision on the court was immediate and profound. In response to what they labeled as a scandalous and wicked judgment, African states threatened to abandon the court altogether. As one African diplomat told the UN General Assembly at the time, and I quote, "The court, conceived at a time when colonial law was part of international morality, no longer corresponds to the needs of an era when the concepts of liberation of peoples has become a fundamental principle of international law," end quote. So the impact of the 1966 decision for South Africa, for international law in South Africa is less well known. So the apartheid state at the time was ebullient at what it framed as a victory at the ICJ, but so too were the white settlers of Southwest Africa who were invested in the continuation of apartheid. And to show their appreciation, they started a fund for international law, which they named after South Africa's lead counsel in that case, Professor Verloren van Thamat, which they then promptly handed over to UNISA. Professor Boersen, who would later administer the Verloren van Thamat Fund for International Law, put the white Southwest Africans' generosity down to their, quote, faith in the objectivity of the law as a result of the 1966 decision of the ICJ, and, quote, belief that public international law would be capable of protecting them against the inevitable black Africanization tide rolling relentlessly southwards, end quote. So what is not known is that Verloren van Thamat Fund for International Law, established by right-wing settlers, would pay for the establishment of South Africa's first 2 international law journals, and I'm proud to say not the South African Journal of Human Rights. So that was namely the Comparative and International Law Journal of South Africa, established in 1968, was paid for by that fund, and the South African Yearbook of International Law was paid for by that fund. Notably, these international law journals, other sponsors included corporate allies and fronts of the apartheid government, including subsidiaries of multinational companies, sanctions-busting companies, and the Attorneys Fidelity Fund. So I tell that story not only because it needs to be told and wrestled with by South Africa's International Legal Academy, but also to underscore the significance of South Africa's second trip to The Hague, and to be sober about the enormity of the task going forward. So more specifically, I want to draw 4 lessons from the 1966 decision and its aftermath in the key of Amilcar Cabral. So first, tell no lies about international law. The 1966 decision reminds us that international law was the engine and freight of colonialism and remains colonial in many respects. In fact, Israel's invocation of the language of barbarism and civilization is not mere rhetoric. It is an attempt to recolonize international law, to invoke its underlying racial grammar in order to demonize Palestinians' opponents and their allies as unworthy of international law's recognition and protection, even when they go to the International Court of Justice. This is not a throwback to language of another time. It is an effort to reset and reassert international law's colonial and racial grammar in the present. Second, expose lies about international law whenever they are told. Since 1994, international law has been feted by our courts, the profession, and South African academics. And since December, it has been rightly celebrated by the public at large. However, the very real risk of uncritically placing international law on the side of post-apartheid South Africa is that we flatten out international law's complex relationship with apartheid itself, shoring up the common and comforting myth that, quote, international law opposed apartheid. This is at best a half-truth. International human rights law eventually opposed apartheid. The majority of the General Assembly opposed apartheid, but international law and institutions as a whole simply did not. Like colonialism, international law laid the foundations for the establishment of apartheid in 1948, and apartheid lasted as long as it did because of, not in spite of, international law and its institutions, including the Security Council, as we know, but also for a time, the International Court of Justice. In this respect, the 1966 decision reminds us that South Africans did not get good at international law overnight, or even in 1994. The uncomfortable truth is that apartheid South Africa was very well versed in the language of international law. Third, mask no difficulties, mistakes, and failures. In the case against the parts of South Africa in the 1960s, there were difficulties, mistakes, and failures, and we need to acknowledge and learn from these. These details are often sidelined by the scandal of how the court came to rule against African states in 1966, namely by the collusion and fraud of the British and Australian judges. But we don't know what would have happened if the decision had gone to the merits, and the assumption is generally made that in the absence of such extrajudicial shenanigans, Liberia and Ethiopia would have won the case on the merits, and the court would have ruled that apartheid violated international law. Truth be told, that outcome was far from certain. In fact, if you read the 7 dissenting judgments, only 2 of them in 1966 explicitly stated that apartheid violated international law. So the first mistake in 1966 was a decision by Liberia and Ethiopia to hire a longtime servant of the US State Department as their lead counsel. Baffling, but a mistake that has easily been remedied this time. The other cracks that emerged in the case against apartheid in the 1960s are more difficult to avoid. They have to do with the legal tactics of the apartheid state, which have already been mirrored in Israel in the recent proceedings. So the first tactic was to dismiss the case as a cynical and political abuse of the court. The second tactic was to take technical points, such as whether there was a dispute or a unispute. The third and most important tactic was to produce an alternative set of facts about the conditions in Southwest Africa, one that contested the UN's narrative and, more importantly, the accounts of those directly affected, then the Southwest Africans themselves, today the Palestinians. So South Africa has done well to counter these tactics, and the court last month came down on the side of the UN and South Africa's well-documented account of the situation factually in Gaza. However, perhaps the most fateful mistake of African states in 1966 was to place all their faith in the justice of international law and its ability to jump its own colonial shadow. In short, the lawyers for Liberia and Ethiopia ended up relying solely on the claim that apartheid, by its very nature, violated international law. It is not certain by any means that they would have been successful, but even if they had, it would have been on the most difficult possible legal argument available. Coming to today, for reasons of jurisdiction, South Africa has no choice but to make the hardest possible argument, namely that Israel is not only wantonly destroying the lives, homes, and livelihoods of Palestinians, but is doing so with the intention to destroy them as a group. There is no other way to the ICJ other than through the eye of this particular needle. It would have been far easier to prove that Israel is committing severe human rights violations or war crimes or crimes against humanity, but to seize the court, South Africa must, for reasons of jurisdiction, rely on the Genocide Convention's compulsory clause. Here, too, just incidentally, the specter of 1966 looms large, as it was because of the 1966 decision and the betrayal of African states that there is no equivalent clause granting the ICJ jurisdiction in the International Covenant on Civil and Political Rights, which was being drafted at the time. So at the time, there was an ongoing discussion about whether or not the ICCPR would have one of these compulsory jurisdiction clauses, and after the ICJ decision, African states removed it completely from the drafting of that convention. Had one been included, South Africa's case before the ICJ would have been far simpler today. However, there are other more hopeful arcs from the 1966 judgment to the present, and I want to end by highlighting 2 of those. So the first is the basis for South Africa's claim today, namely that Israel's genocide against Palestinians in Gaza does not only affect their rights alone, but implicates the rights and obligations of South Africa and other states, as the prohibition on genocide is a jus cogens norm that generates obligations erga omnes partes, to use a Latin term. Simply put, Israel's obligation not to commit genocide is one it owes to all other states in view of their common values and concerns for compliance, so that the breach of that obligation enables all these states to take action. This was precisely the justification underpinning African states' case in 1966, that apartheid South Africa's obligations in respect of Southwest Africa could be enforced by other states and by African states in particular. This radical approach to the enforcement of fundamental norms of international law is also the heritage of 1966. The second arc from 1966 to the present passes through 1973. So in the wake of the ICJ's decision, African states turned to the General Assembly to combat apartheid, but did not abandon international law altogether. Rather, they sought to reimagine and remake international law in order to ensure that it would be on the right side of history and on the wrong side of apartheid. The centerpiece of their efforts was the Apartheid Convention of 1973, which not only declared apartheid a crime against humanity and provided for both universal jurisdiction for its prosecution and a jurisdiction clause for the ICJ to adjudicate violations thereof, but the Apartheid Convention drew a link between colonialism, apartheid, and genocide. In doing so, African states rejected the claims that either genocide was unique to the Holocaust or that apartheid was limited to South Africa. In order to do so, the Apartheid Convention adopted a structural account of the crime of apartheid as a system of political, economic, social, and cultural domination, as opposed to a series of individual rights violations. And by implication, they extended this structural account to the Genocide Convention as well. It was precisely this historical and theoretical understanding of the situation in Gaza that South Africa invoked at the outset of proceedings in The Hague 2 weeks ago, namely that, and I quote, "The ongoing Nakba of the Palestinian people through Israel's colonization since 1948 has systematically and forcibly dispossessed, displaced, and fragmented the Palestinian people, deliberately denied them their internationally recognized inalienable right to self-determination, and imposed an institutionalized regime of discriminatory laws, policies, and practices designed and maintained to establish domination by subjecting the Palestinian people to apartheid on both sides of the Green Line," end quote. As such, South Africa's agent continued, the genocidal acts and omissions by Israel inevitably form part of a continuum of illegal acts perpetrated against the Palestinians since 1948. So notably, going back to 1966, the UN delegate from the Guinea noted with hindsight that the real mistake in bringing the case against apartheid South Africa before the ICJ for violating the rights of individual Southwest Africans was, quote, that it distorted the true nature of the problem of Southwest Africa, which was a colonial problem, end quote. In this respect, what concerns me most about last month's historic provisional measures order are not the words that were missing at the end, i.e. immediate suspension of military operations, but those that were present at the beginning of the order. Namely, and I quote, "The court begins by recalling the immediate context in which the present case came before it, 7th of October, 2023. So the success of South Africa's case going forward will, in my opinion, hinge on its ability to direct and hold the court's attention to the broader context of colonialism and apartheid that are the very conditions of possibility of the ongoing genocide in Gaza. Here, there are no easy victories. International law and human rights law have historically been very hostile to recognizing and redressing structural harms like colonialism and apartheid, or even acknowledging the struggle of the majority of the world's people against them, the legal tactics and traditions and epistemologies that they generate. However, the consequences of doing so will be profound, not only for the immediate case and for the question of Palestinian freedom, but for the question of freedom everywhere, including in South Africa. In this sense, and here I conclude, taken together, the 1966 moment and the recent return to The Hague remind us of the possibility, but also the fragility, of not only a different, more just international order, but of another international law. Thank you.
Thank you so much, Chris. Can we give our speakers for this session a round of applause, please? Okay, as we conclude this session, we are about to go to lunch. We are not going to compromise the time that was allocated for lunch, which is 50 minutes, because as you can see, the last item on our program belongs to the city manager. So he is expected to answer some questions and give answers, as well as do a vote of thanks. So during lunchtime, I'm hoping that he'll be preparing all those questions and answers. So what will happen now, you are all invited. As we go out, you'll turn to your right. The lunch will be provided in the next room. But for the speakers, as we did earlier on, so that you don't get delayed, the deputy mayor invites you to join her with the city manager at the same room, which we took tea. The session is come to an end. Thank you.